Good afternoon, ladies and gentlemen of the jury. Before we start talking about the case, I want to say thank you. I know for many of you that this is a hardship for 2 weeks, and I'm sure I speak for counsel as well when I say thank you. This is a hardship to come in. It's hard enough to come in for 1 or 2 days, but to come in for 1 or 2 weeks, it's a real hardship. And thank you very much. But the reason you're here is because the parties, as you've heard through this case, there's just a disagreement here with respect to what happened, what resulted, what the facts are. And it just couldn't be determined between us. And we had to have help from citizens of Nashville to go through this and assess this. We talked about on the front end also that even though it's a hardship, it's also a very special privilege, which goes back to the 7th Amendment of the U.S. Constitution, to come in and solve the disputes of private individuals like we have in this case. It's not being decided by a computer. It's not being decided by some bureaucrat. It's not being decided even by a judge. It's being decided by 12 people. And you say, well, gosh, how did I get to be picked for this? Well, I can tell you this. When you walked into this room, you didn't walk in. In fact, I don't recall, but if someone was on a jury before, it was only 1 or 2 of you at the most. But I bet you I'm right on this. Not a single one of you has ever been to jury school or taken a class in how to be a juror. When you walked into this courtroom, you didn't walk in and all of a sudden the ceilings of this building opened up and a light shined through down into your head, giving you a knowledge that you didn't have before you walked in this room. What you're doing is actually very easy in many respects. What you're going to do is look at the facts that you've heard through the course of this lawsuit. You're going to hear me, just like you heard counsel a few minutes ago, talking about the facts of the case. But it's the facts you've heard. You sat through it for 2 weeks. Most all of you have been taking copious notes, which is good. Rely on yourself, your own memories, dialogue amongst yourselves. Anything counsel and I may say to you is meant to help you, but what we say doesn't matter. What matters is what you say. So it's the facts that you've heard that you're going to evaluate. The judge instructed on the law, and you'll have a few more instructions when we finish. So it's the facts of the case married to the law that the judge is going to give you with one other factor, and it's common sense. That's all the law is. The law isn't, again, a computer. The law isn't a book. The law is people. You are the law. You talk about the laws in these books over there, the laws in the books in the law libraries. Guess who decided those laws? People decided those laws. So you have a very special privilege here, but a very important obligation as well, because you are the law. With respect to this case, the outset of this is very easy. I'm going to give you some parameters, some context to what it is that we're doing. You've got a plaintiff, and I mean no disrespect to any of the parties at all by referring to what we call them in the law. We have a plaintiff who is suing defendants for damages or for money for damages. And so what you do is you decide then whether the plaintiff is entitled to damages from those defendants. The assessment on that is also easy. Was there an obligation on the part of the defendants to the plaintiffs? Was there a duty? Was there a duty of care? That's the first determination. The second determination is, was there some legal breach or cause of resulting damages to the plaintiff by those defendants? And thirdly, what is the amount of those damages? So again, in that context, what we're talking about is really not that difficult. So to get started, what I want to do is talk about just some of the facts. And the facts in this case are facts that both the parties, we've all been going through this now for some time, learning what the facts are. We've learned quite a bit during the course of this lawsuit that had never been done before, never been known before. And we're going to now go through these facts and talk about them so that you can take them back there with you and decide whether in fact there is some violation of some duty resulting in damages in this case to Ms. Andrews. I want to start with this though. Counsel gave a impassioned closing argument. And I will, if you recall, when I spoke with Ms. Andrews when she was on the stand, we actually agreed on several parts of this case. One is that Mr. Barrett is a criminal. There's no question about that. Counsel's trying to tie my clients to the criminal, but they had nothing to do with that guy. He is a criminal. He is on his own. I would pull a chair over here and put it right here just to separate him out away so that you could see what he's done. But we agree on that. We agree on that. What we've got to do now is determine what my clients did individually. There's two different legal entities here. What each one of them did relative to this case and whether they caused any damages separate from those that were caused by Mr. Barrett. So going through now, and backing up again. What counsel did though is tugged on our sympathies. Again, we concede that Ms. Andrews was a victim of a crime, a terrible, disgusting crime by Mr. Barrett. No question about that. But what he did was tug on sympathies. Again, I didn't write that earlier. Opposing counsel wrote that. And that's what opposing counsel says you can't do. It would be nice to come in here and sit around a table with Ms. Andrews and talk this through with my clients, talk about what happened, have that dialogue, cry, say this was terrible. But we can't do that. We've got to assess a lawsuit. And we can't do that with sympathy. We've got to look at facts. And frankly, it's hard to do that, but we have to do that. So I'm going to walk through what the facts were in this case, just like I did with Ms. Andrews when she was on the stand. And you can take them back there and assess them. And you'll have all the facts that you need after the closing arguments of each of us, with the notes that you've taken, all the witnesses you've heard, and hopefully that will be enough for all of you to make a decision in this particular case. I started off in the opening statement by saying this is a lawsuit about a crime, and that's exactly what it is. A crime by a stalker, Michael Barrett. Michael Barrett, again, you recall from his testimony, was a national director at Combined Insurance Company. A man very successful in his career, whose job was to travel around the United States, go visit different offices of combined insurance companies, and stay at hotels, which he did to the tune of about 200 times a year. He was staying in hotels around this country. Michael Barrett was not just a person that came in off of the street, someone who didn't travel. He was an extraordinarily sophisticated individual when it came to traveling. So that's one fact to start off with. Secondly is Michael Barrett, in his mind, whatever dimensions, demons he may have in that mind, decided that he wanted to start stalking Miss Andrews. Then he made the decision he wanted to not only stalk her, but catch her in a video and try to make money on it because of money problems that he was having. So we start with that premise and we can start evaluating all that Mr. Barrett did relative to Ms. Andrews to accomplish that scheme of his. This is the timeline of events of Mr. Barrett. In February of 2008, he went to the Blackwell Hotel in Columbus, Ohio. That was the first time that he stalked Miss Andrews. He went to the Blackwell Hotel where Miss Andrews was covering an Ohio State University basketball game. While he was there, he removed a peephole and recorded her. It was a very short one, thankfully, but it was a video that he took on that date, February of 2008, Blackwell Hotel. It wasn't long enough, though. He decided that he wanted to take more video. His conscience had gotten to him, so he testified. His conscience got to him, he wanted to do it again. So in July of 2008, he finds out she's staying at the Radisson Hotel in Milwaukee, Wisconsin. He goes to the Radisson. On that occasion, he's staying on a different floor, as you heard him say. He goes to the hotel. He removes the peephole again. He's ready to do what he wanted to do to complete the objective that he had, but he had a family emergency come up, and he left to drive back down to Chicago, a couple hours south of Milwaukee. September of 2008, Vanderbilt is playing the University of South Carolina in the kickoff football game here in Nashville, Tennessee. Mr. Barrett decides that this is the place he wants to come. Nashville, Tennessee, there's an office here for a combined insurance company. He can make it a business trip and come down here, and that's exactly what he did. Came to Nashville, Tennessee, and we're going to talk more about how that happened in just a little bit, but he came to Nashville, Tennessee, September of 2008, went to the Vanderbilt Marriott Hotel, and he took the longer video. After he left, he had that video. He had that video that he took the beginning of September into October, into November, into December, into January. No one but Michael Barrett knew he had that video at that point in time. Nobody knew he had that. In January of 2009, he contacts TMZ, as he testified to, and as we know through the testimony, other testimony in this case, he contacted TMZ to sell that video. TMZ got back to him and said, no, we're not going to buy this. He then waited another month into 2009, into February. No one knows at this point, other than Michael Barrett and TMZ, that he has this video. February of 2009, he uploads it to the internet. Why did he do that at that point in time? Unknown. In his deposition testimony, he couldn't explain it. No one knows. What we do know is in February of 2009, it was uploaded to the internet, some 5 months after he had left Nashville, Tennessee. It then sat on the internet until July of 2009 when it was discovered, when it started trending. And it was discovered that, in fact, Miss Andrews had been videoed the prior September of 2009. So that's the timeline of events that Mr. Barrett did in order to get us where we are today. This is the lease that Mr. Barrett went to. Miss Andrews is the red line. Mr. Barrett is the black line. And what you see is from Chicago, Illinois, where Mr. Barrett lived, he went to Columbus. That was the first trip, the one off to the right. Miss Andrews went up from Atlanta to Columbus. The second one is from Chicago going north to Milwaukee, where that up arrow is going. Miss Andrews went to Milwaukee. And then the third line, Chicago going down to Nashville, Tennessee, and Miss Andrews coming here. So that's the lengths that he went to in order to accomplish this scheme, this mission that he had. Again, the first one, Blackwell. Second one, the Radisson in Milwaukee. And then the Vanderbilt here in Nashville, Tennessee. So that's what he went to in order to accomplish this. We have the background facts. And you say to yourself, I'm going to back up a second. You say, I still don't know exactly how it was that I got picked to get on this jury. I should have brought this up on the front end, so I'm going to digress for just a second. There were a lot of people in this room. A lot of people went through the voir dire process. Why were you picked? Well, and I can guarantee you this also from opposing counsel, we were looking for people that didn't have preconceived notions about the case, could be fair, could listen to the facts, appeared to evidence a willingness to have a practical thought process in assessing those facts. So in this case, we've gone now through the steps that Barrett went through. Then we talked to Barrett. So we have that fact. This is what Michael David Barrett says as he testified in this courtroom. Do you blame anyone other than yourself for what happened leading up to this lawsuit? No. I'm 100% responsible for my actions. 100%. Now, I'm not telling you that he's answering the question. Michael Barrett's a felon. I agree with counsel on that too. Michael Barrett is a felon. Having said all that, he's done one thing in his life, at least relative to this case, that was appropriate. He admitted his fault. You can decide apportionment of fault. That's your decision. But Michael Barrett admitted that he was at fault. Now, counsel says, well, that was a chance. That was a chance for Michael Barrett to get back at Miss Andrews one more time. He'd gone to jail. It's his chance to do that. Maybe you can make that determination. I don't know what's going on in his head. Probably no one in this courtroom knows what's going on through his head. But also, Mr. Barrett, that was a chance for him to blame somebody else, and he didn't do it. That's another way to look at that. I don't know. I don't know what's going through his head. But at least he's taken personal responsibility for what he did relative to this terrible crime he committed against Miss Andrews. But even if you don't consider what he said, there are a lot of other people that testified in this case. Figuring out what happened here took a long time to get there. Those people have come up here and testified for you. Counsel talked about Mr. McWilliams, the supervisor there at the front desk, where is he? Where's Mr. McWilliams? Well, that is a good question. Where is he? He's right here in this city. Why don't you bring him if you had relevant information? A lot of other people came up here. He wasn't needed. If he was needed, he'd been here. He's here. So let's talk about the people who knew the facts of this case and what the input they had to say. Well, first, I want to say this, though. If we're going to assess what the individuals say, what is the duty? We're going to get to duty in a second again with Mr. Delmarva. He says that the duty in Tennessee is a duty to provide a safe and secure environment. Well, this is what the judge has just instructed us on. This is the duty. That's the duty right there. It doesn't say that a duty of a hotel operator is to provide a safe and secure environment. He just read this to us. That's what the duty is. The bottom, a business owner is not an insurer of his customer safety. He must provide reasonable care with respect to the customer safety. So that's the overriding theory behind the law that's applicable in Tennessee. So now let's talk about the different individuals who did come here to testify. But before we get to that, a couple other things. Start with the premise. The way counsel paints the picture of the Vanderbilt Marriott is that nobody would want to go there. It's an unsafe place, terrible part of town, unsafe, criminals going up and down the hallways, and you're just not safe there. No cameras, no guards, and we're going to get to that in a second too. But this is the score that this hotel got in June of 2008, just 3 months prior to this incident in September of 2008. And they got 100% on life safety and security. They're considered an elite hotel within the Marriott system, and you heard a lot of testimony on that too. Marriott has some of the most stringent standards and policies in the entire hotel industry, and they're considered in the top 10% of all hotels elite You also heard a lot about the Marriott International's Pure system. That's Marriott International's Pure system. Counsel talks about documents that weren't produced by my client. Well, we're not Marriott International. We're a Marriott, the hotel here, but you don't need them because what we do have is combination from the Marcia system, the PMS, showing up in an Oscar. Ms. Bonacontre even drew us a diagram how all that worked. A guest, a potential guest, calls up to the Marriott International telephone reservations, and they make a reservation. They go into Pure, then gets put into Marcia. Marcia then is something that interfaced with the local property management system at the local hotel. So everything, all the information that's pertinent to what happened here is here, and it's all been produced. And how would this be? And that's something else. I said, well, these documents have West End Windsor on the bottom of it. Well, that's a good thing, isn't it? To give this information. Isn't that what we're supposed to do, is give the information to Ms. Andrews so she could have it? But how did the information get caught in the first place, or obtained in the first place? In the first place, it was obtained because of the FBI needed it. My clients were working with the FBI trying to figure out what happened with Ms. Andrews and who it was that may have done this and how it may have happened. So these documents were obtained then and then given to Ms. Andrews in the civil litigation. Again, isn't that what we're supposed to do, is share documents? And now to have it held back against my client is not right. But anyway, the documents through the Pure system, PMS, Oscar is what collects it all and then is preserved in the system, showing what we have to introduce to you. What you also heard from Ms. Bonacontre, Renee Bonacontre, the Vice President of Reservations for Marriott, is that part of the Pure system, which again is the Marriott International system, the hotel isn't part of that. They can share the Marcia, but they can't get into Pure, into their Pure system. And part of that Pure system was they had that information section. Information section is only from Marriott International, and she testified that's a system or a mechanism by which they can communicate internally. For example, someone calls up one day to get a hotel reservation, then they call back the next day and say, well, I want to get that reservation. I called about yesterday. You quoted me $210 yesterday. Why is it $235 today? They can pull up that I field, say, no, we quoted you $235 yesterday, because it's all preserved in there through their reservation system. And so Takima Baker made a mistake, and she put the request room next to Miss Andrews in the I field. The I field never went down to the local franchise. You say, well, gosh, man, that sounds awfully fishy. Well, except for one thing. Why in the world would Renee Bonacontre with Marriott International, a VP, come here and lie about that for a franchise? Why would she ever do that? It was a mistake that was made. The proof in this case is that I field never went down here. If there was someone who could dispute that, where are they? Why aren't they in here to dispute that? So it goes into this I field that never got down here to Nashville, Tennessee. What we also know is this. You've heard this through Ms. Bonacontre. And again, why in the world would she say what I'm about to say, which is, in this case, when Mr. Barrett made his telephone call, he testified, and it's funny about this, by the way, can't believe a word he says, but they believe this, that he called the local hotel here. Could be. Maybe he did. Don't know. We don't have a record of that either. It's from his phone, whoever made the telephone call to, but he calls whoever it was. Let's say he calls the local hotel here in Nashville, Tennessee, the Vanderbilt Marriott. He calls here and says, I want to get a hotel room. I need to make a reservation. You've heard from 3 different people tell you what happens when a person calls a Marriott hotel that's part of the Marriott International system, is that the people at the front desk forward that call to the reservation system because the franchise operators are paying a lot of money for Marriott to do that very thing. Ms. Bonacontri says, well, it's quite possible, I don't remember exact words, but it's possible that may have been stronger, whatever it was, but you've got notes, I'm sure, that call was in fact made to Marriott International, and we're the one that confirmed Ms. Andrews' room. That's what she testified to. You also heard from Ms. DeMint, who said, yeah, I get calls like that. That's where I send it off to. You also heard from Herman Turk, who came in and said, the odds are overwhelming. If that call was made here in Nashville, Tennessee, it would have gone off to Marriott International. So what we have here is now testimony. Again, we're having to work through this. You recall that too in the body of forensics. We're analyzing what happened here. How did this happen? How was Mr. Barrett successful in accomplishing what it was that he set out to do? Well, he makes a phone call. He may very likely have called the local hotel here. But what we also know is the odds are overwhelming that if he called the hotel here for the reservation, they forwarded that phone call on to Marriott International to book it for him. Or to confirm the reservation, I'm sorry. We'll get to the making the reservation in a second. When he calls here to confirm that reservation, they forward it on to Marriott International. Marriott International gets the call, and as he testified to, he didn't call and say, we heard that in the opening statement. I want to confirm the reservation of Erin Andrews. That's not at all what the proof was in this case. Proof in this case was that he called up and pretended to be part of the party of Miss Andrews, either a husband, her brother, some close relationship, and was confirming his reservation. He just had Erin Andrews added onto it. So his name, Erin and Andrews, and he confirmed that she was staying there. The odds are overwhelming, if not total, that that call was made to Marriott International, not to the local hotel here. Something determined in the course of this lawsuit, as a matter of fact. So he's made the phone call to Marriott International, ultimately to Marriott International, overwhelming anyway. The question then is, he hung up the telephone, he then calls Marriott International to book his room. That's the I-field that we're talking about. Guest request to room next to Erin Andrews. There is no question that this document was created by Marriott International. Marriott International is not here. Again, I'm representing West End, the franchise owner, and Windsor, who was managing that property. So here's this phone call that's been made to Marriott International. The first one overwhelmingly likely. This one 100% likely, and we'll see testimony about that in just a second. Guest request to room next to Erin Andrews, and that was what was put into the I-field. That information never came down to Nashville, Tennessee. What we also know is that we have the PMS, which again is the local franchise information, the Property Management System Guest History Master. And what we know is when he made his reservation, he's a rewards holder. He makes his reservation and he requests a concierge floor. Doesn't show up there. But he has a king floor on the concierge floor. And the king is a guaranteed king. You've heard that through 3 or 4 different individuals who come up here and testify. So what you now have is a phone call made to Marriott International, likely twice, certainly once, in the reservation. He's now requested a king floor at the concierge level. The concierge floors at that hotel are floors 10 and 11. And we continue to dig through this. How did this happen? So he's now got a king bedroom there on one of those 2 floors. And he gets to the Nashville Hotel. The room isn't ready. We'll get to that in a second. But the room isn't ready. But whatever it is, he's going to get a king floor at that point in time. What you've heard is testimony from several individuals also. about the housekeeping sheets. And the importance of this, again, is that on the 4th of September, which is the day prior, that room is booked to somebody else. The day that Mr. Barrett checks in, it's vacant, ready, but not booked to him. So what is the significance of that? That was created the morning that he checked into the hotel. And on the morning he checked into that hotel, that room was not assigned to him. So what we have here is Mr. Barrett talking about that he had requested the room there next to Erin Andrews. You have Ms. Bonacontri saying that request never would have gone down to Nashville, Tennessee, to this hotel down here. And what you have is confirmation that, in fact, he wasn't assigned the room next to Ms. Andrews when he got down here to Nashville, Tennessee, because it had been assigned. If he had been pre-blocked into that room, his name would be on there just like all these other guests who are blocked into specific rooms. And why wasn't he blocked in that specific room? Because that room is a double-double room, and he had a guaranteed king room that he was staying in. Mr. Strachan had testified, who was the head of housekeeping at the time, spent a lot of time testifying as to housekeeping, how that works, how the room worked. He's the one that walked us through those documents, discussing what they mean, how they're filled out, who fills them out, and the fact that Mr. Barrett would not have been assigned, or had he been assigned to that room, his name would have been on that particular document. But I have to say one thing. Counsel, again, I could flip back to the sympathy page if I wanted to, but I'm not. Counsel talks about profits over safety. There's no proof of that at all. And in fact, this is some of the most poignant testimony, I think, in the entire case.
Yes, sir, I did. It was a copy of my deposition that I did with him a year ago, with the lawyers a year ago.
Did he provide him any deposition after taking after that?
No, sir.
Did we provide him a deposition and taken after that?
He provided me with a few, yes, sir.
Did you have an opportunity outside of our presence to read those depositions?
Yes, sir, I did.
And did you look at the documents that we provided to you outside of our presence?
No, sir, other than the copy of the depositions, no, sir.
The deposition testimony that you gave a year ago, do you feel like you had a complete picture of what had occurred?
No, sir. The information that I shared during the deposition was information that was based on the documents that we had and conjecture.
And whose conjecture?
And mine and Brian Chakowski's.
And based on the documents that you pulled in September of 2009, I'll withdraw the question. Having reviewed the deposition testimony and the documents we discussed today, do you feel you have a complete picture of what occurred?
I have a better understanding of what occurred, yes, sir.
And is it based on that, is it your understanding that Mr. Barrett ended up in 1049 because of the request to be put next to Erin Andrews?
Not necessarily that. Based on the information that I read, it appeared that he worked the system and found a room that just happened to be vacant right next door to her and requested if he could check into that room because it was an early request.
And that's information that you didn't have at the time of your deposition?
No, sir, I did not have information at the time of
And that's
deposition.
information that you and Mr. Chakowski did not have when you were discussing with the FBI?
That is correct.
Is that information you believe Mr. Chakowski would have liked to have known?
Yes, I think he would have felt like it was exonerated us from the fact that we did something wrong.
Does that look like an individual that didn't care about safety, didn't care about their guests? It looked like an individual that took hospitality seriously, and that he did care about safety and cared very much about what happened in this case. So 2 points about that. One, the profits over safety. That addresses that right there. 2 is what he just said, which is what I've been talking about, that in this case, when Mr. Barrett checked in that hotel, he did not have a pre-blocked room next to Miss Andrews. He obtained it some other way. And we're going to be talking a little bit more about that, how that happened, how he was able to connive and deceive and trick like he did. First, we're going to go to Nina Rivera Keene. Ms. Keene talked about the adjoining room request in 2008 and how that would have taken place. Ms. Rivera Keene, if you recall, was the front desk supervisor. She's the one that was actually over Ms. DeMint, who took the reservation when Mr. Barrett checked in. Ms. Rivera Keene also talked about the fact that there was training. Counsel talked about there was no training there. Well, in fact, there was training there. Mr. Strachan testified to it as well. When employees came in, there was book training. They also had several weeks of shadowing to learn how to book someone in at the front desk. There was training there, and that safety was part of that training. You heard that from both Mr. Strachan, you heard that from Ms. Rivera Keene as well. The other thing we learned from Ms. Rivera Keene is that when she had expressed opinions to counsel before in this case, just like Mr. Strachan just said himself, she didn't have all the information. It hadn't been provided to her when the questions were being asked by counsel. It hadn't been provided to her.
And am I correct that your testimony was that if you didn't know who there would be connected to, you couldn't connect it? And so was that, in other words, Mr. Roulette had you stopped, correct? But your answer didn't stop there, did it?
It did not.
Did your explanation of how you could handle that situation stop there?
It did not.
Based on your deposition testimony and your knowledge and experience in having worked 5 years in the front desk as both an agent and a supervisor, what did you testify you would actually do in that situation if you had the hypothetical Mr. Barrett there, if you had an A1 and C1, but there was no indication on the reservation to whom he would be connected or adjoined?
If he didn't tell me, then I would just check into his guarantee room time.
And if you look at the bottom of 78, kind of towards the middle, Mr. Lanzetta asked you, well, what did he ask? What if he said, you know, I'm going to get connected or adjoining to Aaron Andrews' rooms? What would you do in that scenario? What did you justify in that instance?
That I would check her reservation and see if there was any connecting information as far as if she too wanted to be next to that person.
So if you had Susie Johnson, Susie Jones, I can't remember the name of the thing you bring it up. Sally. I knew your honor for that. Now, did you remember the last name? I think it's Johnson. Sally Johnson checks in, says, I would like to be next to Michael Barrett. You check Michael Barrett's reservation, and if he had a note on his reservation that said, I want to be next to Sally Johnson, you would have independently verified that both parties have identical requests, correct? Correct. And having confirmed that both independent parties have corroborated their requests, you would accommodate that request, correct? Correct. So your deposition continues. But what if there was no notation on Mrs. Andrews' room about an adjoining or connecting request back to Mr. Barrett? So you have a one-way street but not the corresponding two-way. What would you have done in that situation based on your testimony in your deposition?
If the person was already checked in, we would wait on confirmation, verbal confirmation.
And that could include simply getting on the phone and calling Ms. Andrews' room saying, I have a Mr. Barrett here who would like to be adjoining or connecting to you, correct? And that's how the front desk would have handled this situation back in September of 2008.
Correct.
And so when Mr. Boyle is having you review pieces of your deposition testimony, he is not giving you the complete picture, correct?
Correct.
He's not giving the jury the complete picture here today, correct?
Correct.
Is your testimony here today something that you want this jury to leave here today with, that you would put the hotel's profits over guest A?
No.
And so if that's the appearance that counsel is trying to make based on your testimony, would that be accurate?
No.
All right. What we also had in this case was testimony from Mr. Barrett that when he got to that hotel, he never once said to anyone there at the hotel Miss Andrews' name. Again, you can disregard all you want to from Mr. Barrett. Whether it's true or not true, we don't know. That's what he says. But what we also know is that facts in this particular case don't show at all that anyone at Marriott, Vanderbilt Marriott here, ever heard Miss Andrews' name. To that end, we have Jackie DeMint, who testified that she was not told his name. We saw one clip, but this is actually what she said. If Mr. Barrett has testified under oath before these ladies and gentlemen that he never mentioned Miss Andrews' name during the check-in, would you agree or disagree with him? I would agree. Is there any doubt in your mind that he never mentioned Miss Andrews' name? No. That was a testimony in this case. I'm sure you've got it in your notes right there. So what we now have is this. You have Mr. Barrett, who says he never said her name. You have Miss DeMint, who says he never said her name to me, and had he done that, because my supervisor was excited she was coming here, I would have gone or my supervisor, I would have gone to him and told him that someone had brought her name up. You have Mr. Rivera Keene, who's talked about that. You have Ms. Bonacontri, VP at Marriott International, who says that field never would have gone down there. Our person messed up, put it in the wrong field. So what you have to believe in this case is that my two clients somehow have been able to persuade the VP of Marriott International to come in here and lie for them. They've been able to convince Mr. Strachan, who's now a general manager at a Holiday Inn, to come in here and lie for them. Convince Miss DeMint, who no longer works for them, to come in here and lie for them. To persuade Miss Rivera Keene to come in here and lie for them. 4 people who are no longer associated with, in fact, one, Miss Bonacontri, was never associated with the Vanderbilt Marriott. 4 people not associated with this hotel to come in and lie for them. Remember, counsel said this, I say this too. We have our common experiences, practicalities, common sense. It all means the same thing, but that just defies common sense. You got those 4 plus Barrett, who have all testified what happened in this particular case. And this hotel here just did not have this information to put him into this room. Counsel talked about David Davenport and the preventive maintenance. He was number 2 in the department there. This is also a courtroom testimony. And what did he say about checking the viewports? The question was, is it your testimony here to the jury today that your department didn't do those checklists? We did do those checklists. And so if there was people that was loose, broken, needed some attention, you all gave it that attention, correct? Yes. And so you don't want to leave with the jury today thinking that you, as second in command of the engineering department, simply didn't do what you were required to do, correct? Yes. That would be another person that would be persuaded to come in here and lie to you for benefit of these individuals. This is somebody, and again, keep in mind that this is the same group that got scored 100% on the Marriott quality assurance test just 3 months earlier. So what you have now are individuals checking people documentation, and all these individuals saying that there was no discussion by Mr. Barrett at any time requesting the room to the hotel here, the hotel room next to Miss Andrews. Ms. Bonacontre also told us a few other things, that between 2005 and 2009, there were 80 million reservations made to Marriott. 3% of those reservations involved a request for an adjoining or connecting room. That's 2.4 million rooms. 3% times 80 million. It's been one time that's happened what Mr. Barrett did in this case. One time out of 2.4 million requests for adjoining connecting room. One time it was Mr. Barrett, and he made that request to Marriott International. He didn't make it to the hotel down here. She also testified that she's been in the hotel industry for 31 years, and she had never heard of something like this happening. 31 years, and this is the only time she's ever heard of this happening. So again, what we have here are the witnesses coming in, presenting the proof to you to go back and consider and evaluate whether in fact Mr. Barrett ever called up the hotel and said, I want to confirm Erin Andrews' room, and then calling back, which didn't happen, and then calling back and having a reservation or requesting a room next to Miss Andrews. That didn't happen. He requested a room, but he got a king bedroom. Now, we're about to get into how he figured out, at least we think, we don't know, only he might know that, how he was able to cause this to happen. But in the interim, our common sense and experience is indicating to us that at least the version that he called and requested this room next to her of my clients just didn't happen. We also have in this case experts. Mr. Delmarva testified for the plaintiffs. Mr. Delmarva said something very important in his testimony. Prior to Mr. Barrett doing this, he had never heard of something like this happening in the industry. He'd heard a couple times, that was it, of staff at a hotel taking a viewport or a peephole and turning around so you view from the inside or from the outside to the inside. But he had never heard of a criminal activity such as what occurred in this case, removing the peephole, cutting it off, recording, doing anything, committing a crime through a peephole like Mr. Barrett did in this case. Not only, by the way, did Mr. Delmarva not hear about it before 2008, he didn't hear about it until 2015 when Mr. Carr, counsel for plaintiff, called him up. So he didn't even hear about this until 7 years after the fact, which is also interesting. Mr. Barth had testified that this was earth-shattering within this, my word, not his, within the industry, and everybody heard about it within days or weeks or months. But Mr. Delmarva didn't hear about it for 7 years after the incident occurred. Counsel had said something I thought was interesting in his closing. He gave an example on foreseeability, and that's what we're talking about right here. Mr. Delmarva saying he'd never heard of this before would indicate some issue, whatever it may be worth to you, on foreseeability. But he gave you an example. The individual that would be in a minor car accident and have a whiplash, and then walk down the street a couple weeks later and a tree falls down and falls on their head, causing much more serious injury. That's not foreseeable. That was his example. That is not foreseeable. Well, what do we have in this case? we have an individual, Mr. Barrett, who goes into a hotel. We're arguing, we're contending that the removal of the peephole, filming with a cell phone, as he did, hacksawing it off, that in and of itself isn't foreseeable. But let's say it is, but it's not. But let's say it is, taking his argument. Made the video through the peephole, and then months later is when he uploads it to the internet. That's exactly the situation, the example that he just gave. The tree falling several weeks later on this individual who had the whiplash from before. In this case, you've got someone taking a video through the peephole, and if that peephole or that video had never been uploaded to the internet, no one would have ever known about that but Mr. Barrett. That's exactly the situation that we have in this case, was the example that he gave. Mr. DeMarvo also testified to several other factors. You know, and I'm sorry to jump about this. I'm obviously not good with these, but Ms. Bonacontre, I do want to play this, if I could. This has to do, before you start, this has to do with whether she is sure that this information wouldn't have been sent down to the Marriott. You cannot get any more sure than you're about to hear. Were you able to get that? Well, what you recall her saying, again,
How certain are you that that information was never communicated? Up here. Or later that the jury understands. So based on your analysis of these documents, your experience, was the notation, yes, request room next to Aaron Andrews, communicated through Marriott International Preservation System to the PMS at the National Marriott?
It definitely was not.
And how certain are you that the request was placed in the item?
100% certain.
And how certain are you that that information was never communicated to the hotel?
100% certain.
Could the protest agent that actually checked in Mr. Barrett have seen that request contained in the info?
No, I could not.
And how certain are you that the protest agent that actually checked in Mr. Barrett could not see that comment?
I'm 100% certain of that.
That's it.
she testified that it could not have been sent down to the National Marriott. She is 100% certain that it was not sent down here to the National Marriott. What number was that? Can you tell by looking at that? Which video, which slide that is?
21.
Thank you. All right, so Mr. Delmarva has talked about foreseeability. He had never heard of this before. You also heard from Mr. Barr, who said this had never happened before. You also heard from Mr. Strachan, who testified, never heard of this before. You also heard from Ms. Bonacontre. In 31 years, this had never happened before. Ms. Andrews herself testified, just as I would, just as probably everyone in this courtroom would, couldn't envision someone doing something as perverted and disgusting as what Mr. Barrett did. This just simply was not foreseeable. Mr. Delmarva, though, testified beyond the foreseeability, which again, he testified that he'd never heard of this before. And he testified that there were no guards. There were no guards. Therefore, there was a violation of the standard of care. There were no guards, except for one thing. There was a guard. Big Tim. Tim Easley. Tim Easley was their daytime guard. They had a nighttime guard that they got through Cumberland for the night shift, but in the daytime, they had Tim Easley. Who'd you hear about Tim Easley from? Jackie DeMint, Mr. Turk, Mr. Strachan. That's three people who talked about Mr. Easley. Now, why Mr. Delmarva would come in the courtroom and testify there were no guards when they've testified in this case that there were and they've been deposed, don't know. But there was a guard there. There was a guard there. Mr. Barth also testified not only did you have this security guard, Mr. Easley, but you had the employee staff. As he testified, there are a lot of staff in the daytime. That's why you need to guard at night, because you don't have the cleaning crew. You don't have the staff that's walking around. In the daytime, though, you've got your housekeepers, you've got your restaurant workers, you've got your maintenance people, and they're the eyes and the ears of the hotel. They're walking the floors on a constant basis. Counsel may discuss that you don't expect a housekeeper to go and do something, to intervene in something. Well, that's certainly accurate. You may not expect them to do that, but they're watching, and they can sure go pick up a telephone and call the front desk and get the security, or call the Vanderbilt police or the Metropolitan Police and get somebody over there. So you've got the eyes and the ears. So you've got the security guard, Mr. Easley. You also have the eyes and ears of the hotel working on the floors at the time. Mr. Delmarva also testified that there was an absence of surveillance cameras, and that was a violation of the standard of care. Say for two things. One is, he said, I'm not saying that you need to have cameras in hotels. I'm not saying that at all. I'm just saying in this case, this hotel should have had cameras. Why? Why would this hotel have had to have cameras? He didn't explain. He gave no explanation at all. Well, Mr. Barth talked about that in 2008, and even today, surveillance cameras are not inside of hotels on the guest floors. You have them in the public areas where the public is going to be, but on the guest floors, you don't have them. Well, why is that? Again, use your common experiences. You walk into a hotel. Hotels are about guest experience. They're about hospitality. You walk into the guest floors there. Does it make you feel warm and safe and secure walking down the hall, looking at security guards as you walk down that hallway and security cameras as you're walking down that hallway? In fact, that's the opposite, according to Mr. Barth, of what the hospitality industry is all about. He also testified that the policies and procedures at the Vanderbilt Marriott met or exceeded the standard of care in 2008. He also testified in rebuttal to Mr. Delmarva on the back of he called it the back of the house phone, concierge phone. By the way, counsel said that Mr. Barrett referred to them as house phones. He did, but he also referred to them as concierge phones. Doesn't matter. He's wrong what he calls them. It's a back of the house phone. It's an employee phone. It's a phone that has the little LCD screen on it, so that you call down and you say, I need to pick up my car in 30 minutes. When the desk can tell you, okay, Mr. Dedman, your car will be ready. Or you call down, you say, can I get a sandwich sent up here to my room? Okay, Mr. Dedman, we'll have it up to you in 45 minutes. As Mr. Strachan and Mr. Turk talked about, it's a touch point. It's a way that you enhance the experience of the customer when you say their name and you say thank you. You use their name in doing that. So that's the purpose of those telephones. And as Mr. Barth testified, those phones were the standard of care and were used in the industry in 2008. In fact, they're still used to this day for the same purposes. All right, so in this case, you've got testimony from now Delmarva, never happened before, Barth, never happened before, Turk, something like this had never happened before, and Ms. Bonacontri, something like this had never happened before. You have the analogy that counsel had given, which is exactly on point here. In this case, what Mr. Barrett did was simply not foreseeable. It was not foreseeable that some criminal would go to the steps that he did. And by the way, he didn't just do it, again, with, he just video Miss Andrews one time. He also did the Blackwell Hotel, tried to do it at another hotel, and as the proof was in this case, he also did it 10 to 15 other women at hotels around this country. This was a perverted individual that had this I can't even explain what it was that he had, to go out and film women in state of undress like he did. And there's no evidence of it ever happening again, before or after. Classic definition of foreseeability right there. In this case, you have, again, the issue of the negligence and whether the acts of Mr. Barrett are foreseeable. And I discussed this a few minutes ago, and that is when he did this in the first place and committed this act, that was one act. But he had that second act all those months later in February where he actually uploaded it to the internet. Is that act foreseeable? Even assuming that the other things were, that someone would then take that and upload it to the internet, is that foreseeable? In this case, we have, on top of the liability issues and the negligence issues, the damages issues. Damages, this case is a case premised upon negligence. Ms. Andrews is suing for compensatory damages, damages that compensate her for the injuries that she has sustained. And in assessing that, what is it that you look at? Well, there's a lot of discussion about the question of what has happened with your career since this occurred. It wasn't to say that this career benefited her. I mean, this incident benefited her. The purpose of that was to show that it's not a significant injury. Dr. Brown had testified to that. She looks at these markers to assess what is the damage that has been sustained in this case. Has her career improved? Is there a relationship, which she now has, which she had not had before? Has pay increased? So these are all factors that go into the assessment of compensatory damage. What is it that you compensate the person for the damages they have sustained? In this case also, July of 2009, Ms. Andrews learned of the videos. In early 2012, Mr. Barrett was released from prison and sentenced to 30 months. He served 20 months. In 2012, Ms. Andrews moved from Atlanta to New York. And then in March of 2012, which is almost 3 years after the incident, she began seeing the clinical social worker, Warren Comstock, in New York. Ms. Comstock saw her until April of 2013. And then Ms. Andrews moved to New York, from New York to California in January 2014. In June of 2014, she began seeing Dr. Dupay. And that's another interesting point. Counsel talks about missing witness. Where's Dr. Dupay? And this is Ms. Andrews' psychiatrist. Why is she not here? Why is she not here to give us some opinion on what her thoughts may be? We heard from Dr. Brown, but we didn't hear from Dr. Dupay. Last visit with Dr. Dupay, May of 2015. Dr. Brown's assessment was that Ms. Andrews' psychological functioning is pretty good and that she's not experiencing significant psychological distress overall. Ms. Andrews is a resilient, stable person who functions fairly well psychologically despite the horrible experiences that she's been through. Very straightforward with respect to her opinions. Not a serious injury. And in fact, she's testified that with cognitive behavioral therapy, 24 total sessions, she would expect significant improvement, if not resolution, of the symptoms. She also discussed what the cost of that would be, about $5,000. Counsel contrasted that with internet views to discuss how much she should be compensated. Okay, we wanted to talk about that factor. Talk about the number of people that are viewing the video. But if you recall, there was that spike back in 2009 or 2000. 2009. Since then, it's been very low. But it's not a proper mechanism of measuring anyway. What are the damages that Ms. Andrews has put forward to the jury today? In this case, counsel is suing Westin and Marriott, two different entities. We had talked about in the voir dire process. Now, may I approach real quick?